Well, hi everyone. I'm delighted to welcome you to our video legal podcast. And we have a very interesting subject I suspect many of you are always interested in, and that is criminal law. I'm John Deary, and I'm delighted to welcome our very significant attorney in the criminal law area and a very dear friend, Mike Croce. Mike, so delighted you're here.
Hey, John. It's really good to see you again.
Believe me. Let me start by asking you in a general way, what is the role of a criminal defense attorney?
The criminal defense attorney is your best friend when the police come knocking in the middle of the night.
Yeah.
A lot of people have the dilemma, the question, should I talk to the police? Should I invoke my right to remain silent? I don't want to look guilty. The truth of the matter is no one should speak to the police without an attorney, especially when they are involved in an investigation of some type of criminality and there's something to be concerned about. And I want to preface this by saying anyone who has a legitimate issue where they are the victim of a crime or they feel that they really need the assistance of the police should feel comfortable reaching out to the police and cooperating fully. But if you're the subject of an investigation, then you should avail yourself of your right to remain silent, avail yourself of your right to counsel. It will pay dividends down the road.
We'll get onto a lot of specifics, but let me ask you generally, what is the 2 or 3 major pieces of advice, generally speaking, that you would give to a prospective client?
Well, first, don't speak to the police. Don't speak to the prosecutor without your attorney present. Get an attorney involved as soon as possible. It's one thing for you to say, I want to talk to you, but I want to talk to you with my lawyer present, as opposed to say, I don't want to talk to you at all. I don't want to talk to you at all makes you look guilty. I want to talk to you with my lawyer present makes you look like you're just protecting yourself and invoking your right to have counsel. The government has attorneys. They're always working for them. Prosecutors are working 24/7 on their investigation with law enforcement. You should have someone who's looking out for you.
What do you think is the major concern of someone not having an attorney and interacting, for example, with the police? What's the major concern?
Well, there's a couple of things. First, you don't know what they know. Long before the police come talking to you, they've been investigating. State level is one thing, federal level is something totally different. But in most cases, before a police officer or a detective knocks on your door, they've been doing their investigation. They've been looking for video. They've been speaking to people. Sometimes they've even been doing something like running your cell phone records. Cell phones have become a very, very big investigative tool for law enforcement. One of the most beneficial tools to law enforcement, I would say, in decades. It's a GPS tracker, tells the police everywhere you've been. It tells the police your innermost thoughts, because we talk and we text to everyone we know what's going on in our minds. And it's also a record of who we're talking to, when we're talking to them. So it is a plethora of information about you. And law enforcement will often have much of that information before they even invite you to come and sit down.
Do defendants have essentially a constitutional right to an attorney?
Yes. Interestingly enough, that wasn't always the case. Even though the United States Constitution talks about the right to counsel, early on the Supreme Court had interpreted that to mean only in federal cases, and it did not apply to the states. Sometime around 1965, I think it was, a case called Gideon versus Wainwright, which is law 101 as soon as you go to law school, guarantees every individual who's charged with any type of criminal offense the right to counsel. So yes, absolutely.
You made before a reference between state and federal litigation, and you seem to make a distinction and the importance relative to the individual client. What were you thinking about?
Well, state prosecutions tend to be more transactional. I think events that occur As they're occurring, law enforcement responds, arrests are made, investigations are conducted, and cases are proceeding almost day by day in real time. Federal cases are very different in that they're usually investigated for many years before you're even aware that there's an investigation going on. Federal prosecutors will often speak to your friends, to your family. They may even arrest some people that you know with the hopes of bringing them in and having them cooperate against you. So that by the time you're actually marched into a courtroom, there's volumes of evidence that's been collected against you. And you're looking at a mountain of evidence that you're trying to climb out from.
A client, if he or she chooses, can represent themselves, but you were very, very strongly in opposition to that.
Absolutely, absolutely. The right to represent oneself is something that the Supreme Court has said every individual has that right. However, it's important to recognize that the practice of law is exactly that. It's an art form. It's a practice that is performed by people who have been trained in the law. Anyone who wants to represent themselves may know the facts of their case better than anyone, but they don't know the law. They don't know the nuances in the law. And judges will tell those individuals that if you're going to act as your own lawyer, you're going to be expected to understand and know the terms of art that other lawyers would understand. They would know the statutes that might be quoted, or case law that might be quoted. And for example, I said Gideon versus Wainwright earlier. A court might say, we're referring to Gideon without talking about the fact that it stands for the right to counsel. And unless you had that background and that knowledge, you would be lost and playing catch up, trying to figure out what everybody is saying around you.
Can an individual select an attorney and begin the process? And if for whatever reason, are they able to change attorneys?
Yes. So unlike most civil litigation, where where you have this period of time where you're consulting with lawyers and speaking to them about issues that you either want to pursue as a plaintiff or where you've been sued, and issues where you've been sued, criminal litigation begins with an arrest. New York City happens to be one of the best places for criminal defendants, because everyone who's arrested is provided with an attorney at their criminal court arraignment. So in New York City, you will see an attorney within 24 hours of your arrest, sometimes earlier. And before you see a judge, you'll have an opportunity to speak to an attorney. You'll learn what the charges are against you, and have a conversation about the process going forward. Now, that lawyer that's provided for you is there for indigent individuals, people who can't afford counsel. And if you are fortunate enough to be able to hire your own attorney, you'll be expected to hire your own attorney, and will have the opportunity to do so after that initial arraignment. If that attorney, by the way, is unable to make it to that arraignment. There's many times I get phone calls in the middle of the night, and I run down to the courthouse to do a late night arraignment.
One of the ways that you can break the law down is criminal and civil.
Yeah.
And my question is, why have you gone into the criminal law practice?
Civil law is a great practice of law, and it's a great opportunity to be very successful financially. There are great financial opportunities in civil law. Criminal law, oftentimes you find yourself confronted with people who don't have the means to pay for their lawyer. They're the people who are looked at oftentimes just because of the crime that they've been charged with as the lowest level in our society. It's important to recognize that at least under our law, everyone is supposed to be looked at the same in the eyes of the law. And to be able to stand next to someone who's been charged with a horrendous crime and try to humanize that person and make sure that despite all the slings and arrows that are coming that way, there's somebody there to step in front of that person and protect them. Because unfortunately, and it doesn't happen often, but it happens enough, the system sometimes will snatch up a person who just doesn't belong there, John. And that poor person is still dealing with the stigma of the arrest, the stigma of the charge, the stigma of the prosecution. And the only one there that's screaming for their innocence is the attorney standing next to them. That is an honorable profession. That's something I've always wanted to do. It's always been very interesting to me, and I'm so thrilled that I have the opportunity to do this.
Do it and do it so extremely well as you do, Mike. Is everything that a prospective defendant will tell you as the attorney confidential?
Yes. Conversations are protected as privilege, as all conversations with attorneys are. Any conversation that a person has with a lawyer where they're seeking legal advice is protected. That lawyer is barred from disclosing the substance of that conversation. The client is free to talk to whomever they want to, but the lawyer is barred from sharing that information. As an attorney, we have an obligation to preserve and protect that privilege. Unfortunately, sometimes lawyers get casual, they get sloppy. They have conversations in places where they should not be having them. Privilege is only as good as as the efforts are made to protect that privilege. So keeping those conversations confidential are what keep the privilege in place.
To me, this is one of the most interesting questions to ask a criminal defense attorney, and that is when a potential defendant explains and confesses to the guilt of the crime, how do you deal with that situation?
That's a good question. It doesn't happen as often as you would think. You would like to think that at some point in the relationship, the client feels comfortable enough to be completely truthful and honest with you. I'll share an experience. I had a client once who I was able to work out a deal, which was a very good plea offer for him. He had been maintaining his innocence. He had been demanding a trial. He had told me that he was not going to take anything. And then when I obtained this plea offer for him, he said, okay. And then during the plea allocution, which is where he's questioned about the facts of the case, he started offering information that only the person who was involved would know. And I was kind of looking at him like, how'd you know that? How'd you know that? Yeah. When you learn that from your client, of course, that's something that is never going to leave the privity of that relationship, unless at some point it becomes necessary in order to advance the case with, for example, with working out some type of a plea offer, a plea deal. Remember, Sammy the Bull Gravano pled guilty to 19 murders and hundreds of other crimes long before he testified against John Gotti. And he had to have that come to Jesus moment where he talked about things he never wanted to talk about, but it was to his benefit, and so that's why it worked out.
Who decides to accept the plea deal?
Only the defendant can choose a plea. There's only three things that a defendant has an absolute right to determine, to talk about. The first is whether or not they are going to accept a plea offer. The second is whether or not they're going to testify at trial. And the third, and this is something that most people don't ever talk about, is but there's a right to what we call a judge trial or a bench trial versus a jury trial. If there is a legal technicality that you think you should be highlighting at trial that might be in what they call a legal loophole, an opportunity to avoid liability, oftentimes you want to take the emotion of the case out of the picture and present it to a judge who doesn't have and who would look at it more objectively than subjectively. But you have to have that conversation with your client. You can't simply waive the jury without their consent.
Who makes the determination as to whether a defendant testifies at a trial?
Again, solely the defendant's decision.
Really?
With the advice of his attorney.
Have you dealt with situations where you advise one way or the other, yes, testify or no, and the defendant goes the other way?
Absolutely. I I've been doing this now for 30 years, so it's very different when I have these conversations with my clients. But early on, when I was relatively young and working as a defense attorney, I had a client who, on two separate occasions, told me he was going to testify. And I strongly advised against it. And in each case, he decided he was going to testify. One was before the grand jury, and then later on at trial. In the grand jury, he testified and he was indicted. And at the time, the law was kind of ambivalent as to whether or not he had a right to testify in the grand jury. And so I allowed him to testify. Today, I would absolutely have stopped him. No one has a constitutional right to testify in the grand jury. It is a statutory right. And the courts have said that I, as legal counsel, make that decision for my client. But at trial, that's a different story. And in another case, a client who I told he should not testify, I told him we had the win, decided he was going to take his chances and testified, and actually admitted to 2 crimes on the stand. And of all the crimes that he was charged with, those were the only 2 he was convicted of. So it is.
What are you thinking about vis-a-vis, yes, we recommend that you testify, or otherwise?
A lot of it has to do with your client's ability to tell a story. And sometimes you know that right away. You can tell that this person knows what they're talking about and can communicate it in an effective, meaningful way. Most people are not gifted orators. Sadly, most people don't know how to tell a story. And in the hands of a gifted prosecutor who can question them with cross-examination, can take them down a path of inconsistencies and contradictions that would often make their entire story, no matter how truthful it may be, can seem extremely false and like a lie. The second thing is whether or not there's really something to be gained by the testimony. Simple things like presence at the scene of a crime are things that that the government has to prove. They have to prove that you were there. They have to prove it was you who committed this crime. And most people's defense is, well, I was there, but I didn't do it, right? I was there is one of the things they have to prove, and you're going to give that to them just to say it wasn't you? That's what your not guilty plea did. They have to prove it. But if you have a self-defense claim, or if you have what we call a legal justification claim, an affirmative defense, then testifying is almost an imperative. You have to get up on the stand, or at least I would encourage my clients to take advantage of the fact that the judge will tell the jury that if you believe this story, you must find them not guilty.
Is a defendant who testifies, I have 2 questions, about what percentage of your clients testify, and how effective do you think the attorney testifying, and or in the negative, if they do not testify, is that generally a negative against them?
Very small percentage, less than 5% of the clients will testify at trial.
Oh, really?
Yeah.
Oh, okay.
Again, there's rarely a benefit to testifying at trial. If you're there and you're on trial, odds are we are challenging the evidence against you. We're not presenting a defense. We're challenging the people's ability to prove their case beyond a reasonable doubt. That's not to say that there aren't a number of people who I would love to put on the stand, or would have put on the stand. Sometimes the risks don't outweigh the benefits. The benefit of testifying, to your second question, is that jurors want to hear both sides of the story. They're told they're not entitled to it. Unlike a civil trial, which you are very familiar with, John, there is no right to remain silent in a civil case, but there is one in a criminal case. And that silence cannot be used against you. And jurors are told that by the judge. And where a negative inference is given to the jury, in other words, the jury would be told in a civil case, you can take the defendant's silence or the witness's silence as evidence that if they were to testify, it would hurt them. There's no such charge in the criminal law. So the silence of the defendant is something that can't be used against you. However, your last question was, do jurors look at it at favorably? Sadly, I think most jurors want to hear from a criminal defendant.
And are hence a little disappointed if they don't
I
hear?
think so.
And yet you're talking only 5%?
Yes.
So 95% put the risk with the jury that they may not be pleased with the fact that they're not testifying.
It's worth it. The benefits outweigh the losses.
And what are the losses that you're concerned about by having someone testify?
The vast majority, well, especially in today's age, John, where we have video, we have cell phone data, we have DNA, the forensic evidence.
We have, or you're talking about the...
Well, the government collects it. We see it. We know what it is.
Yeah.
We are inundated with more than just testimonial evidence these days. We don't have to worry about whether the police officers acted inappropriately because the body cameras are on, and they're on from the moment they interact with the clients. They're on when they're interviewing witnesses. Every building on this block has a Ring video camera or some type of surveillance camera outside. And if anything happens in front of this building, the police will go to all of your neighbors and they will collect their video footage. There's license plate readers that capture vehicles as they're driving throughout New York City. Not just the license plate, but very often images of the people inside of the car. People with their cell phones who are just, as they're walking down the street, videotaping themselves, having lunch, dinner, breakfast, are capturing events all around them. The amount of digital and forensic evidence available, including DNA evidence, is overpowering. And sometimes your best argument is to challenge the weight of that proof against whether or not they have enough to at least charge you with the crime. Yeah, we got enough to bring him here, but you haven't overcome that burden of proof beyond a reasonable doubt.
Do you find clients face a more challenging time now than they might have done 5, 10, 15 years ago? In other words, are the cases more challenging now than earlier?
In a lot of ways, yes, because as I said before, the amount of evidence that's collected and that's available to law enforcement is so much more readily available, and it's so much more abundant. However, the climate has changed. So countering this law enforcement advantage of amazing amounts of evidence, we have new information about implicit biases, and we have a tenor, a tone in the community of people who want to be a little bit more forgiving or welcoming of individuals who might be struggling and might be pushed towards, some of those more or some of those less violent types of crimes, the low financial crimes. So in some cases, there's the bias against the accused, but there's also bias against the police. And jurors who have this bias against the police might be more willing to look at your attack of the evidence than they may have been 15 years ago. We started with O.J. Simpson. In fact, it came out even very recently where they were interviewing some of the jurors, that many of those jurors figured that they were never going to convict O.J. Simpson because they felt that the Los Angeles police were so racist and that they had targeted him. So that's not to say that that's what's going on here today, but people are more forgiving. They're more willing to hear those arguments, and they will often give the defendant a benefit of the doubt where they may not have many years ago.
On the civil side of it, there is, relatively speaking, very much fewer cases that go to trial. My question to you is, what do you think the percentage of cases that you deal with go to trial?
Probably a little bit more than the civil side. Again, the numbers are low, and it also depends on where you are. For example, Bronx County historically has had very, very favorable defense juries, because most of the people in Bronx County uh, have grown up in the community. They're not sheltered. They're not living in the suburbs. They're not living away from what's going on the streets. So they have a better sense of what's happening out on the street. And so Bronx jurors tend to be at least a little bit more willing to listen to a defense in a criminal case, as opposed to maybe some banker from Wall Street who's upset that he's got to be on jury duty, let alone he's dealing with somebody who's charged with a crime that he just finds morally reprehensible. Um, the number of cases that go to trial are a lot less than you would think. I think we get very favorable plea offers when cases get to a point where there's a choice of going to trial or resolving the matter. But the truth is that there are some cases that will have to go to trial because the sentences are too high, the crimes are so horrific, and there's never going to be a meeting of the minds. It's going to be up to a jury to weigh in and cast a verdict.
What do you deal at all with conflicts of interest?
All the time. All the time.
In what way? How do they manifest themselves?
Well, unlike in a civil case where one lawyer might often represent more than one client on the same side of the caption, in a criminal defense case, just the fact that there's a co-defendant creates a potential conflict if you're representing that other individual. The reason for that is simple. We co-defendants do not have shared interests in the outcome. You may think that they both want to be found not guilty, but levels of culpability and liability play a role in how each individual's case might be defended or attacked at trial. So if I'm representing, John, and his brother Michael is an overbearing bully who bullied him into robbing a bank or into engaging in some type of an assault, John's got a defense against his brother. He was somehow coerced. He was forced. And so there's a conflict there. And if I'm representing Michael, I would have a duty to protect Michael as much as John. And how do you resolve that when John's best defense is to point a finger at Michael? So the conflict always emerges when you have multiple defendants. And for that matter, and for that reason, John, we have here in New York City, we have multiple defense organizations that are in place to represent individuals who cannot afford counsel and still have individual representation in their case. They don't have to worry about one lawyer who's taking care of the guy next to him at my expense.
Do many clients use that kind of free service?
I would say most of the criminal defendants in New York City are receiving indigent counsel defense services.
And who is paying for that attorney?
There's a budget through the Office of Court Administration. It comes from the state down. It's also part of Gideon versus Wainwright. When that decision was passed, each of the states had to come up with a means of funding a public defender organization. New York State has one of the greatest indigent defense systems in place with the Legal Aid Society, which is probably the premier criminal defense organization in the country. And then we
Have you ever, at an earlier stage in your career, done any of that work?
I did it, but I did it with the prosecutor's office. I went into the prosecutor's office, and then when I left the prosecutor's office, I actually undertook a representation of criminal defendants through what they call the assigned counsel plan, also called the 18B panel, something you may recall from when you were in the assembly. The assigned counsel plan is essentially private lawyers who contract with the state to represent indigent defendants when there's a conflict of interest.
In anticipating the possibility of being a defendant and everything that goes along with it, what advice do you have for clients that are in that situation?
Find the lawyer that you can talk to. Communication with your lawyer is the most important thing in the legal relationship. I make it a point of returning every call. I don't care when I return that call.
Yeah.
If you ever read the disciplinary committee reports, very often one of the greatest reports is the lawyer doesn't call me back. The lawyer doesn't talk to me.
Yeah.
Communication is the be all and end all. I don't expect my client to tell me the truth, but I expect my client to talk to me. I expect to tell them the truth. I always tell my clients that I'm not here to tell you what you want to hear. I'm here to tell you what you need to know. And if you don't like it, that's fine. We can talk about it some more. You can fire me. You can hire another lawyer. But if I'm telling you this because you need to know this. And unfortunately, what I have to often tell my clients is not what they want to hear, but they definitely need to hear it.
Are you suggesting that your perspective on almost any client that comes in is basically you're not going to get the full story from them?
I don't expect the full story. In fact, John, very often I don't even ask them early on in the case about what happened. It's not relevant. It's not necessary early on. What I need to know early on are things that most lawyers want to know from their clients. I want to know your background. I want to know where you come from. I want to know where you live. I want to know contact methods. I want telephone numbers, email addresses. I want to know your family. I want to know who I can talk to and who I can't talk to. I want to get as much information about you as I can about your education, your schooling, whether or not you have a history of learning disabilities, or maybe even some mental health issues that were in there. All of this is a package of getting to know the client. Sadly, most people who are caught up in the criminal justice system are struggling with some type of either substance abuse disorder or mental health issue, or a combination of the two, which is even worse. So we want to know as much about the client so that we can at least figure out who this person is, so that when the time comes to have that conversation about what happened, we can have that conversation. When I have that conversation, I know more about their case than they think I know. I've reviewed the videos. I've seen the witness statements. I know what the people are saying. And so when they're talking to me, I can get a sense of how honest they're being with me. I'm not here to confront them or challenge them, but I am here to walk them through what the evidence is, so that together we can kind of blaze our path through this case to some type of a resolution.
How is a criminal attorney paid?
It depends. The indigent defense panels, the legal aid societies, the county defenders are organizations that contract separately with the state, so they get their salaried employees. You do not pay your criminal defense attorney in those agencies. The 18B panel, or the assigned counsel plan, also is paid by the state, and so you do not have to pay that lawyer. If you're not indigent, or if you have the means to pay for a lawyer, then you and your lawyer will work out a mutually beneficial payment plan to kind of resolve whatever it is that you need to talk about. Again, a lot of this has to do with the nature of the case. And I'll tell you, for example, that the vast majority of people who are going to be paying for their lawyers are people who are involved in offenses like driving while intoxicated, or maybe they had an issue with the tax authority. These are people who have businesses or are working and get caught up in their daily life, in their daily business. And their lawyers will either work out some type of a retainer agreement or some type of a flat fee arrangement. When you talk about the more serious violent crimes, most of those people don't have the resources to pay their lawyer. Most of those people are receiving indigent services, indigent counsel.
At the end of the day, just a final question, and that is on punishment. What basically, ultimately, is a defendant facing in terms of punishment for a prospective crime?
I don't know how much time we have here, so I'll be very quick, and then you tell me if there's something you want me to expand on. Essentially, there are a couple of different types of punishments that are available to a judge who is sentencing an individual. Only the judge can determine a sentence. Prosecutors and defense attorneys, they can make recommendations to the judge. Most of the time, and when I say most of the time, 99% of the time, the court will go along with a mutually negotiated plea. But it's up to the judge to impose a sentence. Sentencing can be anything that most people have paid: a parking ticket, a traffic ticket. It could be a fine. We could have probation. We could have community service. And unfortunately, then on the more restrictive side, we have incarceration. Sentences of a year or less would be served locally in the county facility. In New York City, that's Rikers Island. Outside of New York City, it would be the county jail. And then sentences of more than 1 year, a year and a day or more, are served in a prison, usually in a county upstate New York.
Mike, this is a subject, as I said at the outset, that people are interested in and have had experience, family or friends or whatever. And I mentioned what a prominent attorney you are
Thank
in
you,
this
John.
field, 30 years of experience,
Yeah.
and it certainly sounded that way. Thank you so much,
Thank
Mike.
you for having me, John.
It's a real
Appreciate it.
pleasure. Great to see you.
Same
Thank
here.
you.